Hello and welcome again. We've been discussing the depredations imposed on us because of COVID and moved on to means of resisting these by using the invocation of Article 61 of the 1215 Magna Carta. In any discussion about a political issue, the question of rights inevitably arises, and it's not before time that we move on to that topic. The range of things that people want to classify as rights is very wide, as are their notions of the source of such concepts and how they should be administered in a just society. Most people pay lip service to the concept that rights should be equal for everyone. But many then proceed to list things as rights which cannot possibly be provided equally to all members of society, when some thought is applied to the problem. Our common law rights evolved over time because it became obvious that if some rights were not universally applied, there would be inequity and injustice in the community. Such things as the four tenets already mentioned: do no harm, cause no loss, commit no fraud, and keep the peace, can be applied to every member of society and impose no unreasonable or coercive measures upon anyone. Before going into further detailed discussion, we need to qualify some terms. What exactly does the term rights mean? In one discussion, a friend contended that there are no such things as rights, and that all human activity revolved around what people could acquire or defend by whatever means they devised, including violence and deception. Certainly, there are many people, and always have been, who live by this principle. But does its application by anyone who feels like behaving this way lead to a harmonious or just society? Most would say not. Many people argue that rights are God-given, and others that rights are inalienable. In other words, that they may not lawfully be abridged or infringed by hostile action. Some people today have become conditioned to believe that rights are something which are granted to us by the government or some other authoritative body. The existence of a deity is not necessary for the existence of rights. For if there is no deity, belief in which remains, however widespread, but not scientifically demonstrated, would that mean that rights also don't exist? Or that human beings are incapable of formulating why rights should exist, or how they ought to be maintained? Similarly, if rights are granted by the government, how is it that they can apply equally to all? For in that political gene pool, some will be the dominant dispensers, and others the recessive recipients. My answer to my friend was that rights stem from that which is natural and normal in the real world. Thus, all living things seek to sustain and prolong their existences according to their innate capabilities as they interact with their environment. Plants seek what they need to survive, as do animals, and no one has any issue with these things. Humans might bemoan the fact that sometimes they fall prey to carnivorous or venomous creatures, but there are no protest movements claiming that such things ought to be forbidden by either a deity or the government. In common with all other living entities, it is natural for humans to seek to sustain and prolong their lives. And we are blessed to be able to solve these problems most of the time by application of our intelligence and physical effort. If each follows the 4 tenets of the common law, the community benefits greatly by our decision to cooperate, even if competitively, rather than from a widespread practice of preying on each other like animals. A right, therefore, stems from what would normally happen if people respected each other's innate requirements for existence. In a stable, functioning world, it is right that living things strive to continue living, according to their individual or class natures. That is what I mean by the term right. It is a literal manifestation of natural order. The actions of animals and plants are driven by instinct or simple responses to environmental stimuli. Human action, by contrast, is driven by a mixture of emotional desires, but functions most beneficially for the community when these innate desires are modulated and directed by the exercise of intelligence rather than simple violence or deceptive cunning. This also raises the question of whether something can be a right if it must be provided by someone else, presumably at the other's expense, thereby causing a loss. Is it logically consistent to argue that such claimed rights can apply equally to all? Or are rights limited to what would be available purely in the natural world, such as those which would exist under the 4 tenets of common law? My answer to that question is a simple yes. Humans' greatest asset in this struggle for existence is our intelligence, and it follows that if the exercise of this talent is excessively limited by coercion, or worse still, actively prevented by criminals or tyrants, the quality of life available to such victims will fall well short of its potential. The cost is not only severe for the individual victims, but is compounded by the beneficial effects of sensible cooperation being denied across the entire community. Economists term this phenomenon a wastage of human capital, and every so-called democracy in modern times suffers greatly from it. Our politicians are either ignorant of this effect of their preying upon the societies they are supposed to serve, or so corrupt that they simply don't care, provided their own palms are well greased. The third alternative, and the one most supported by evidence, is that this progressive removal of our rights is a deliberate, malign strategy executed by people who use legalities to hide their true intentions and to enable numerous unlawful activities against honest, law-abiding citizens. This leads on to the issue of why constitutions must be written by the people, not those who are going to exercise power. In a society based upon the 4 tenets of common law, every citizen would be free to act for their own benefit without permission, while those serving in the government would only be able to act with the consent of all citizens. We are clearly a long way from this situation. What has gone wrong? What needs to be rectified? Our problems stem from the fact that the exercise of power tends to corrupt people. As soon as the Magna Carta was sealed, those on the upper rungs of the hierarchy sought to enhance their positions by weakening those securities which it granted to the much more numerous plebeians. The common law, known as the law of the land, began to be replaced by elements of the Roman law, the maritime law or law of the sea. The language of the law was corrupted by legalese, where what people understood as plain English came to have obscure meanings, discernible only to those trained in its use. Perhaps the most used example is the apparently simple question asked by police or magistrates, "Do you understand?" Most people simply reply yes to that. But in legal terms, the question actually means, "Do you stand under me?" By answering yes, the person unknowingly places themselves under the jurisdiction of the inquirer. The correct answer is to simply say, "No, I stand," or to ask, "Do I have the right to remain silent?" Then, when having that right approved, to simply say nothing more. The exercise of unlawful power, therefore, tends to inspire greed or lust for the unearned, even amongst hitherto honest people. It is imperative that this abuse must be curtailed. If it is not, the result is always an outbreak of violence, either from the authorities against those who show resistance to their perfidy, or from the victims who find that their positions are no longer tenable or are inimical to an acceptable quality of life. To transfer this exercise of power from the unlawful to the law-abiding, the goal must be to dismantle the system of legalistic hocus-pocus and replace it with a common law system of trial by jury, whereby cases are decided by juries of true peers, selected as closely as possible from the vicinities of those petitioning or defending the issues, not by highly paid and possibly venally motivated magistrates or judges. For those opting to get into lawful standing under Article 61, the best aim, demonstrated so well by David Robinson and his associates, is to avoid appearing in these illegitimate courts at all when unlawful demands are made upon us. The more people who can thus repel this tyranny, the sooner these ultimate goals become attainable. Thank you.